Hello friends, my name is Shubhajit Banik and I'm a lawyer. Welcome to my YouTube channel, The Lawyer's Law for Students. At the very outset I say, the purpose of this channel is basically to help the students to take the examination easily so that you can recall in a jiffy from where the question is put. Alright? Today we take part 11 of the Constitution of India. The what is part 11 of the Constitution of India? It's a very, very important part. The relations between the Union and the states. The relations between the Union and the states. Right? The part 11 is divided into two chapters. Firstly, legislative relations, and secondly, administrative relations. Alright? Legislative relations and administrative relations. That much is clear. Okay. So far as the legislative relations are concerned, very important. It's an afternoon law, we may say, 245 the time. So Article 245 in substance says that the Parliament may make law for the whole or any part of the territory of India. Clear? And the legislature of a state may make law for the whole or part of the territory of the state. I'm putting my words, but basically Parliament can make law for whole of the country, and for the state it's the state legislature. All right, that's 245. Now we come to 246. At 246 it relates to the 7th schedule. All right, how? See, before I start with 246, I may tell you this thing, that in the 7th schedule of the Constitution of India, there are 3 lists, L-I-S-T-S, lists. They are called List 1, List 2, and List 3. Again, List 1, List 2, and List 3. These 3 lists in the 7th schedule of the Constitution of India have within themselves certain subjects indicated. All right. So list 1 has, say, some subjects, list 2 has some subjects, and list 3 has some subjects. These subjects are technically called entries. All right. List 1 has some subjects, list 2 has some subjects, and list 3 has some subjects. These subjects are called entries. All right. And the reference point is made entry 5 of list 1, or list 1 entry 5, meaning thereby the 5th entry or the subject is serial number 5 of list 1. Clear? Entry 31 list 2, meaning thereby the subject at serial number 32 of the list 2. Similarly for list 3. List 1 is called union list. All right. List 2 is called state list, and list 3 is called concurrent list. List 1 union list, list 2 state list, and list 3 concurrent list. Easy? Good. Now, the power of the Parliament and of the legislatures of the state to legislate on the subjects or entries is discussed and indicated in Article 246. Clear? The power of the Parliament and the legislature of the states to legislate on the entries in the 3 lists are indicated in Article 246. It says that the Parliament has the power to legislate on list 1, on the entries in list 1, that is of the union list. All right. So in union list, the state legislature cannot legislate. Am I clear? If a subject or an entry, or it's also called a field, is indicated in the union list, so only the Parliament can legislate laws. The state legislature cannot legislate on that subject. Clear? Right. So far as list 2 is concerned, herein only the state legislature can legislate. The parliament cannot. All right. So the states, by way of legislation made by the legislature of that state, can legislate on the entries or the fields or the subjects in list 2. Clear? And so far as list 3 is concerned, that's the concurrent list, the power is there both on the parliament and on the state legislature to legislate on those fields. Am I clear? Clear. But there are some exceptions also. We'll discuss them. We'll discuss a little bit later. Right. Article 246A. It's all about GST, Goods and Services Tax. It says, both the parliament and the state legislature of every state, both are competent to legislate on GST, Goods and Services Tax. That much is easy, 246A. The rider is, if the GST, the Goods and Services Tax, is in relation with interstate trade and commerce, right? State A, State B, interstate trade and commerce. If the GST is applicable within this zone, only the parliament has the power to legislate. GST is a different thing, different aspect altogether. We're not discussing GST. But under Article 246A, if the Goods and Services Tax falls within interstate trade and commerce, only the parliament has the power to legislate. Okay, right. Now we come to something important. We leave 247, we leave 248, the residuary powers. These are technical issues. Theoretically, basically, we come to the important things, 249 and 250. I said the exceptions were there. All right. 249 and 250 talk about the situations when the parliament can legislate on subjects which the state legislature can legislate. Simply, suppose there is an entry in list 2 which the legislature of the states can legislate, all right? Or a state legislature can enact a law because it is there in the state list. Now there may be certain conditions or situations when the parliament takes over that power. What are they? Article 249 and 250. How? Article 249 says, in national interest, parliament may do so. Just remember that. Article 249, national interest. How do you remember? 249, N-I-N-E, right? So N-I is there, national interest. Clear? And Article 250, in terms of, in cases of emergency. When there's an emergency in the country, all right? Or there is an emergency in the state declared, then the parliament can legislate on subjects in the state list. Clear? So 249 is the parliament can legislate on state issue, on the subjects in the state list, or when there is a national interest. I am not on the procedural part. We'll talk about that later, how the Council of State says, what is the majority part. We're not on that. On the basics, 249 is in national interest and 250 in cases of emergency. Gone. Easy? Easy. Most important are 251 and 254. Why? What happens when there is an inconsistency in laws, right, passed by the legislature of a state and by the parliament? Right. The Parliament of India passes a law and the state legislature also passes a law, and there is a provision of the state legislature which is inconsistent or repugnant with the law made by the parliament. What happens then? Article 251 and 254 discusses only this part, right? Understand, since Article 251 is nearer in sequence to Article 249 and 250, so Article 251 discusses what happens in cases of laws passed in powers under Article 249 and 250, meaning thereby laws passed by the parliament on fields occupied by the state list in exercise of 249 national interest or 250 during emergency have a different footing than those generally, right? Okay. How? If a law is passed by the parliament during emergency or in national interest touching upon a field of the state list, it's a valid law. All right. Now, if a state legislature also passes a law where provisions are in conflict, there's a repugnancy. All right. Now, may I make it clear that Article 249 or 250 does not take away the power of the state legislature to legislate. Right? It does not. So, if a state legislature legislates on a field legally competent to do so, but some provisions or a provision is in conflict with a provision made by the parliament in another law, and that law was enacted in exercise of powers under Article 249 or 250, national interest or emergency, then to the extent of such repugnancy, the law made by the state legislature shall be inoperative. All right, shall be inoperative, and the law made by the parliament shall prevail. Once again, in exercise of powers under Article 249 and 250, that is, in national interest or in emergency, if the parliament enacts a law, right, and if the state legislature also enacts a law, the provisions of which are in conflict with such laws enacted under Articles 249 and 250, then to the extent of such repugnancy, such conflict, such inconsistency, the law made by the state legislature shall be inoperative. 251, I is there, 1 is there, it looks like an I, so inoperative. Am I clear? And 251 only comes in situations when the law is made by the parliament in exercise of Articles 249 and 250. Clear? Okay. What is 254 then? 254 says, if the parliament has passed a law competent to do so, right, in matters of the union list or in cases of the concurrent list, right, then if the state legislature also has passed a law, right, the provisions of which are inconsistent, repugnant. Now, this is not a situation of 249, 250. Otherwise, exception, not in 249, 250 generally. If the parliament passes a law on matters on which it is competent to legislate, and the state legislature also passes a law on the subjects of fields or entries, which it is competent to legislate, and if there is a repugnancy now, then to the extent of such repugnancy, the law made by the state legislature is void. Yes, void. 254, VOID, 4 letters. Remember it that way. 254, void. 251, inconsistent, inoperative. Clear? So, Articles 251 and 254 both deal with situations when there is inconsistency of laws made by the parliament and the state legislature. Article 251 deals with the situation when the law enacted by the parliament is in exercise of powers under Article 249 and 250, that is, national interest and in emergency. Then, if there is inconsistency of such law with any state law or provision of state law, to the extent of such repugnancy, inconsistency, the law passed by the state legislature shall be inoperative. To help you remember and recall, I say 251 is nearer in position to 249, 250. So 251 has to deal with national interest at 249 or emergency at 250, correct? And says 251 has 1 at the end. 1 looks like an I. So the effect is state legislature, the law passed by the state legislature to the extent of that repugnancy is inoperative, right? And in 254, we are not visualizing a situation of 249, 250, but otherwise, if the parliament is competent to make a law, and it so enacts a law, right, whether under the union list or under the concurrent list, then if there is a repugnancy with a state law, the provisions of which are repugnant to that extent, it becomes void, right? But there is a rider. What is the rider? The rider says, in case of concurrent list, if the state legislature passes a law and it is reserved by the president for his assent, and assent is passed, then for that state, to the extent of repugnancy, it's correct. The law is valid. All right. Understood? 251 and 254. Right. I'm not dealing with all the articles, the basic articles. And now for the administrative relations, just remember 263 is interstate council. 263 is interstate council. You cannot remember and recall all the articles. You have to understand the basic articles. So interstate council in substance says the president may by order establish a council, basically for disputes which arise between two states, right? To look into those disputes, there are technical words for that. Then to talk about the policy matters, some policy, and on issues of common interest, to investigate and discuss or to inquire and adjudicate on the disputes. So these are the things by which an interstate council basically looks into, and it is established by order of the president, Article 263. Remember Article 263, interstate council, the three letters, the three words, if I say 263, however you remember, but it's 263 is interstate council. But always remember, interstate council would come under relation between union and states, interstates, right? Okay. Now a few very important things I need to tell you. That is some doctrines, all right? Doctrine of pith and substance, all right? Doctrine of severability, doctrine of incidental encroachment. What is it? And what are they? Understand. Under Article 246, we had understood that legislative competence means the Parliament can enact laws for entries in the union list or list 1 and in the concurrent list along with the state, and the state can enact laws for entries in the state list, list 2, and with the Parliament in the concurrent list. So concurrent list both can do, state list only state, and Parliament can do in Parliament on the list 1. But in other situations which we discuss in national interest or in emergency or otherwise, then the Parliament may also legislate for the state in the subjects in the state list. But if there is a conflict, now there's not conflict of laws. It's not conflict of the provision of one legislature, the act passed by the state legislature with an act passed by the Parliament. No, it's not that. If there is a conflict or a question of legislative competence, what is to be done? Example. In a famous case, I'll explain with an example. In a famous case, in the case of Rajasthan, in the state of Rajasthan, it's a post-independent thing, okay? Post-independence, this one. Now, the state of Rajasthan has enacted a law on amplifiers, okay? I recall vaguely, I do not recall in detail, but in substance I can tell you, amplifiers. The legislative competence of that act was challenged. The grounds were that amplifiers fell in the union list, okay? Say for broadcasting communication, I forgot the entry, it was there. In substance, the law on the amplifiers fell within the union list. In broadcasting, communication, telegraphs and post, telephone, something like that, within that entry, the scope of that entry, the amplifiers would come, and therefore the Parliament would have the power to legislate and not the state, that is the state of Rajasthan did not have the legislative competence. See, repugnancy of a provision and the legislative competence are two different things. Clear? So the state of Rajasthan did not have the legislative competence. The counter argument by the state of Rajasthan was that health, if I remember correctly, came under the state list, and if it is under the state list, then amplifiers relate to noise, so this would also come under the state list. A law to regulate on this. Eventually, it was said that the act was a valid act, all right? Now what do we learn from it? It was held that although amplifiers is there in the union list, but the power to legislate in the field was there in the state list. How? The test was of pith and substance. So in essence, the true character, what was being legislated, all right? If this is in essence, what was being legislated fell within the legislative competence of the legislature of a state or that of the Parliament, then the fact that it encroached incidentally on a separate list does not make it invalid, all right? So the test used was of pith and substance, the true character. So now it was tested in pith and substance. It is always applied when the legislative competence of an act is put to challenge. It is seen whether the parliament or the legislature of a state has the basic competence to enact on that subject. If yes, on the true nature, if yes, then the fact that it incidentally touches upon an entry of any other list does not make the law invalid. All right. So pith and substance is taking out the basic nature, character of the subject and to see whether it falls within the list of which the legislative competency there of the union or of the state. Clear? Now, if the legislative competency is there, then the mere touching on the other entry of the separate list is a doctrine of incidental encroachment. It just touches and comes back, nothing so bad. All right. It does not make the law bad in law. Right. Again, if we take a condition, say that there is an act and certain provisions are there which are repugnant to the parliament law, state legislature. So what is to be done? We know when it is inoperative and when it is void, all right. But to make out a working condition, a workable condition, a test is put. That is to see whether those things to the extent of inconsistency or repugnancy can be separated, taken out or severed, and then the act in substance remains intact. All right. If yes, doctrine of severability is applied. That means to that extent of inconsistency or repugnancy, if that part can be severed out, it is severed. So doctrine of severability. I am not taking on this, but see how it correlates to this part of the Constitution of India. You must understand, right? So if question is put like doctrine of pith and substance, on which it's Article 256, that's something to understand, all right? 246 relates to the schedules. The schedules have lists, the lists have entries, and the legislative competence. That's one. If when the state legislature can, when the parliament can pass laws on the state legislature, on subjects on the state list, then it's 251, 249, 250, sorry, national interest and an emergency. What happens in inconsistency? They're twofold. One, it becomes inoperative, and the other, it becomes void. 251 and 254. So these are the concepts. What is interstate council? Under what article? 263. In substance, we have discussed about part 11 of the Constitution of India. All right. Try to go through the books, follow the lecture. It will be helpful for exams. And listen, if you've liked it, do share and subscribe. Let us reach out more people, more students. Let us all study together. Lockdown time should be a study time, isn't it? That's the motto. Take care. Enjoy.